Greeting to you, ladies and gentlemen, for coming to the court today. Now, in this splendid afternoon, we will start our court between Indonesia and Australia delegate over the Ashmore Island dispute. For the detail of the chronology, it will be known from the judges. So please obey the rules until the court is finished. Ladies and gentlemen, the court is starting now.
The main case in this dispute is Ashmore and Cartier Islands dispute between the two parties, Indonesia and Australia. Ashmore Island covers 155.4 square kilometers and is divided into three parts. West Islet with 51,200 square feet, East Islet with 21,200 square feet, and Middle Islet with 21,200 square feet. The area of the Cartier Island is 44.3 square kilometers. The case begins with the activities that carried out by the traditional fishermen who come from Rote Island. Indonesia and Australia have a Memorandum of Understanding or MOU regarding the activities of traditional Indonesian fishermen to catch fish around Ashmore Reef Island. MOU 1974 regulates the provisions of fishing, the rights and obligations of fishermen, and other provisions. However, in early 2003, Australia suddenly banned Indonesia fishermen from fishing around Ashmore Island for environmental conservation reasons. Australia claims that Ashmore Reef and Cartier Islands are part of Australia, and starting from July 2003, Australia closed all types of fishing activities by Indonesian fishermen on Ashmore Reef. The unilateral action taken by Australia received critical comments from the Indonesian government, because Indonesia was of the opinion that Australia should hold bilateral talks between countries, considering that the island was also under Indonesian management at that time. And Indonesia claims that Ashmore and Cartier Islands are part of Indonesia territory. The act of claiming the two islands created a dispute between Australia and Indonesia.
As an archipelagic country, Indonesia has a lot of islands since a long time ago. At the time, Indonesia was known as Nusantara or Hindia Belanda, but sadly, at the time, Nusantara was under Dutch colonial control, which made the Indonesian native unable to control the world of the island. The colonies also make the natives cannot claim the island or Nusantara because all the power and sovereignty is in the hand of the Dutch. All of those reasons make Nusantara lose power over island. One of the islands that Nusantara loses is Ashmore Reef, or known as Pulau Pasir in Indonesia. Since geographically, the Ashmore Reef belongs to Indonesia because the location of Ashmore Reef is in the area of 60 miles from the Rote Island, the region of Rotendao, Nusa Tenggara Timur, which means Ashmore Reef closer to Indonesia than Australia. And historically, the natives who worked as fishermen looking for fish around the Ashmore Island. The activities carried out by the fishermen are evidence that Indonesia have entered Ashmore Reef way before Australian. The Australians said Ashmore Reef was given by England due to colonialism and made the island theirs, but at the time Indonesia was under Dutch colonial that made us cannot do anything when England claimed Ashmore Reef and gave it to Australia. Even the Dutch colonial claimed Ashmore Reef, they won't give the island to Indonesia because of the Dutch way of colonialism. On the other hand, when England claimed the Ashmore Reef, Nusantara has no power against that decision. So make an agreement that England claimed the Ashmore first is not fair because at the time Indonesia was a colony and England was a powerful country that has a lot of colony.
From the historical story, since hundreds of years ago, fishermen from Rote, Sabu, Alor, Flores, Bugis, Buton, and Madura extended their exploration of the island. And there are even 16 coconut trees, springs, and many other things that can be calculated as evidence of the fishing activity of Rotterdam can be found on the island. Indonesian fishermen since 1750, under Dutch colonization, have gathered some of the potential bahari, such as dripping and fish, ships from Makassar, South Sulawesi, that entered the region of Timor with permission from the Dutch India government in Batavia, or now Jakarta. And in the 1800, when the British colony claimed Ashmore Island, Indonesia was still under Dutch rule. And the last time Ashmore coral reefs had been claimed by the British colony was in 1878. Its reality was even more difficult when it was clearly calculated that the distance between Ashmore Reef and Rote Island, its Nusa or entity, was only about 80 miles, and between the island and Australia's northern Queensland, Australia.
Based on the historical explanation and evidence that has been submitted, Indonesia still have the rights to the Ashmore Island. Moreover, Indonesia fishermen have been doing fishing in this area before this right is recognized. It means that Indonesian fishermen have traditional fishing right which is based on history. Indonesian fishermen have met four qualifications in accordance with traditional fishing right, that is, 1. The actual existence of sufficiently long fishing activities must be established. 2. The area visited by fishermen, that is, the fishing ground visited, should be relatively constant. 3. Fishermen themselves, in the sense that the right shall be granted only to the same fishermen who have visited the area traditionally. 4. To the equipment and vessel used, as well as the amount of catch in the end sense to qualify under the meaning of traditional fishing right, the vessel used should be relatively traditional. Regard to the state obligation to respect traditional fishing right, it is better if we enter into an agreement to protect the traditional rights of fishermen that fishing provisions in this area.
Dear Our Majesty, the opinions from delegates of Indonesia may be true, but look at the topics on this court. If we talk about an island, reef, or islet, we are talking about sovereignty. Dealing with sovereignty means we don't consider distance. Regarding the status of Ashmore Reef conflicted with Indonesian exclusive economic zone, is indeed not quite right. Just because a reef lies within Indonesian EEZ, it doesn't necessarily mean that it belongs to Indonesia. The sovereignty over a reef cannot be carelessly decided. It is not depending on its distance to a state's mainland. It deals with legal aspects. A document in Netherlands reveals that Ashmore Reef was annexed by Britain in 1878, together with Cartier Island. Ashmore was transferred to Australia on 23 July 1931 and is then part of the Northern Territory of Australia at 1938 till 1978. In 1978, Australia established Ashmore and Cartier Island Territory, and finally Australian government formed Ashmore Reef National Natural Rivers on 16 August 1983. Of course, we don't have to trust the internet site, more intensive studies need to carry on. According to the CIA, one of the sources, people made truth reveal similar facts. CIA's World Factbook confirms that Ashmore Reef is under the Australian sovereignty. Another support also comes from GE Search in UK. By plotting the coordinate of Ashmore Reef at 12 degrees 90.98 south degrees, 128 degrees, and 4.98 east degrees. In the Indonesian-Australia EEZ boundary map, it is clear that Ashmore Reef lies within the Australia EEZ. This implicitly implies that Indonesia has acknowledged the Australian sovereignty over the reef. From a historic point of view, it is true that the ancestor of Timor people come to Ashmore Reef since 1630. However, the Netherlands never secured the reef in its colony territory, and the government administering the reef was Britain. Indonesia couldn't claim Ashmore Reef just because their ancestors came there, did economic activities and died in the reef, provided that the government administering the reef was not its predecessor. In Netherlands, the Indonesian proclamator Sukarno and Hatta secure all the former area of the Netherlands, not the others, as people in those areas had the same experience during the colonialism. It is indeed ironic that Indonesian, exactly Timor-Leste and others, who have been visiting and carrying activities in Ashmore for hundreds of the years, are not entitled to own the reef, while Britain, now Australia, who discovered Ashmore in the 19th century, secures strong rights. But look at the theory. But look at the reality. We are talking about law, and it is worth noting that modern law emphasizes legal claim rather than visits and activities. If it is true that Britain legally claimed and administered Ashmore Reef and the Netherlands didn't protest, its sovereignty will obviously be Australia's. For further evidence will continued by my partner.
In 1971 to 1972, Indonesia and Australia agreed continental shelf or CS boundary or SID, where the boundary line located far north, close to the island of Timor or Indonesia. Some experts opine that it is not an equitable boundary. Apart from the unfairness and the failure of Indonesian diplomacy in the past, it is worth understanding that the agreement was signed before the UNCLOS came into force. Therefore, the quality of the agreement could not be judged using UNCLOS. The Australian argument emphasized the principle of natural prolongation. The data available at that time suggested that the natural break of the Australian continent and Indonesian continent exists too close to Timor Island, so that the continental shelf boundary lies far from the median line favoring Australia. This practice was supported by legal development at that time. The ICJ's judgment on 20 February 1969 regarding the North Sea continental shelf case between Germany and Denmark, for instance, significantly considered geomorphology of the seabed or the principle of natural prolongation. In other words, Australian argument was supported by jurisprudence. However, the development post UNCLOS tends to consider seabed geomorphology less. In the case of Libya and Malta in 1985, for example, the ICJ decided that within 200 nautical miles, seabed geomorphology is irrelevant, and the court's judgment was based on distance principle. It might be true that the continental shelf boundary between Indonesia and Australia is inequitable. However, it is worth noting that the decision was with regards to the positive law applicable. If required, Indonesia may renegotiate the boundary with Australia, provided that Australia agrees to do so. However, it is most likely that Australia does not want renegotiation. Another agreement requiring attention in the 1997 EEZ boundary, unlike the continental shelf boundary. This is much more equitable as the border lies in the median line between the two states. Unfortunately, Indonesia has not yet ratified the agreement in its internal law. Regarding Ashmore Reef, there is an MOU in 1974 to 1975 allowing Indonesian traditional fishermen fishing around Ashmore Reef. Surprisingly to Indonesia, Australia in 2002 to 2003 restrict Indonesian fishermen from fishing in the area due to environmental conservation. This must attract the attention of Indonesian government, and it should responsibly clarify this as this endangers Indonesian fishermen's life.
Undoubtedly, it is Indonesian obligation to keep archipelago exist and united. However, clear understanding regarding legal, technical, and scientific aspects are essential. Everybody should carefully analyze and be more critical toward every single issue regarding border conflict. A wrong decision may lead Indonesia to huge material loss as well as reputation degradation, as it might be considered as an emotional and irrational society. The available legal evidence so far tend to suggest that Ashmore Reef is under Australian sovereignty. It is worth mentioning that Indonesian society should have learned much from recent cases regarding boundary and society. Reading news in the paper and electronic media, it is understandable. Indonesian can be easily emotional and sometimes irrational. Legal, technical, and scientific aspects are often beyond news concern. It is Indonesian love sensation more than information, even though the Indonesian delegate giving their best arguments, but their opinion an argument suggesting that is a part of the Indonesian territory has any weakness and didn't support with valid evidence. So let's do the panel of the judge do their best to achieve and the most equitable solution for both sides decide who will winning these problems.
The judge Willie Harvey read out the list of evidence submitted by both parties, which include the following: 1. MOU Box 1974. 2. Agreement on technical guidelines for the implementation of the 1974 MOU. 3. Port Agreement March 14, 1997. 4. The SIG Working Group on the Marine Invasion Indonesia and Australia March 19 until 20 in Nusa Dua Bali, Indonesia.
Based on the evidence and arguments that have been presented and explained by both parties, the panel of judges considered that A. The evidence which are submitted by Australia and Indonesia fulfills both formal and material requirements. B. The argument put forward by Australia is proven that Ashmore Reef Island, which coordinates 12 degree 13.98 south longitude, 123 degree 4.98 east longitude, in the boundary agreement map between Indonesia and Australia. The two islands are in the Australian EEZ region. This implies that at least in 1997, when the EEZ agreement was made, Indonesia through its diplomats have recognized Australia's sovereignty over the Ashmore Island. C. The next following argument from the Australian side. The concept of natural continuity, which says that the natural boundary of the continents of Australia and Indonesia is indeed near the island of Timor, so that the continental self-boundary is far from the centerline in Indonesia, which the concept is changed by jurisprudence, namely the decree of the International Court of Justice, or ICJ, on the 20 February 1969, about the case of the North Sea continental shelf between Germany and Denmark, which significantly takes into account the geomorphological conditions of the seabed and the concept of natural continuity. Point D. The panel of judges conclude and argue regarding the arguments from the Indonesia side, which say that fishermen who came from Rote Island from the past or from the time of their ancestors carried out fishing and marine activities, or activities had not been able to prove strongly that Ashmore Island belongs to Indonesia. With the history of the activities of these fishermen, it cannot be used as strong evidence for Indonesia to claim Ashmore Reef Island. Or in other words, there is no strong jurisprudence which regulates that Ashmore Island is included in the territory of Indonesia. Then, the panel of the judges considered the arguments of fishermen from Rote, Sabu, Calor, Flores, Bugis, Buton, and Madura, who said that they had entered the island area in 1750, long ago before Australia was not strong enough, or in the other words, the strength of the argument was weak, because it was not can be proven formally and materially.
based on historical background when the British colonies ceded the island of Australia side in 1931, and after that it was claimed as part of Western Australia. Meanwhile, Indonesia failed to claim because it only proved and confessed the history of Indonesian fishermen from the island. In the process of handling this dispute, the government of Indonesia and Australia faced several agreements, such as MOU Box in 1974 and the Perth Agreement in 1997. After that, going through the trial process, convening opinion and approving it, it is clear that Ashmore Island claims belong to the Australian government and become an important part of maritime territory of Western Australia. For the sake of justice, based on the one and only divinity, the judge hereby adjudicates 1. Approve the evidence submitted by Australia and Indonesia meet formal and material requirements. 2. Approve the agreement put forward by Australia, which proved that Ashmore Reef Island was coordinate are 12 degree 13.88 south longitude, 123 degree 4.88 east longitude in the map of boundary agreement between Indonesia and Australia. The two islands are in the Australia EEZ region. This means that at least in 1997, when the EEZ agreement was made, Indonesia, through its diplomat, recognized Australia over Ashmore Island. 3. Reject the argument of Indonesian side which state that fishermen organization from Rote Island from the past or from the time of their ancestors did fishing and marine activities. 4. Determine that the agreement of fishermen Rote, Sabu, Kolor, Flores, Bugis, Buton, and Madura, who said that they had entered the island area in 1750, long before Australia, was not strong enough or elsewhere. The power of the argument is weak because it cannot be proven formally and materially. So the dispute win by Australia and Ashmore Reef Island belong to the Australia.